And of course, in this hour, we are talking about alimony. There are some states which have declared that the idea of permanent alimony will no longer be part of divorce settlements. Warren Farrell is on the line with us. And Warren, just before the break, you were talking about the skewed, I gather, statistics as you see them in regard to women's earnings versus men's earnings.
Yes, when you look at not just the category like nurse or doctor, you will find that male doctors and male nurses both earn more than female doctors and female nurses. When you look more closely at the category, you find that the subspecializations that men and women work in, tend to lead, for example, men are far more likely as doctors to be cardiologists. Women are far more likely to be general practitioners. Male nurses are more likely to be nurse anesthesiologists. As a rule, nurse anesthesiologists earn over $100,000 a year. And so what's really helpful to our daughters is to teach them which specialties earn more and which specialties earn less if we want them to earn more. But when we control for the specialties, the number of years worked, the number of hours worked per week, the willingness to go to places that people don't want to go to, locations that they don't want to move to, which pay more. When you control for variables like hazardous work and so on, and you put the 25 major variables together, only about 7 or 8 of which are normally controlled for, then you have women and men earning about equal, maybe women earning a little bit more for the same work, same time.
Then get back to the issue of a fixed termination date for alimony.
I think 10 to 15 years is really a very valid time. I think alimony does have a useful purpose, and we shouldn't go from one extreme to the other. When a woman or a man takes off to be full-time involved with the children, he or she does lose many years that are useful in the workplace. And when my father, for example, he left a job because my mom wanted him to leave a job because she was depressed in Europe, came back, left a job as a manager of a major company, came back and sold full of brushes. Now, he wouldn't have applied for alimony, but it's an example of when he was 50 years of age, it was difficult for him, as it would be for a woman, to find a job even when he was productively in a managerial position for a long period of time.
All right. Warren Farrell, he's an activist and author of several books, including Why Men Earn More and What Women Can Do About It. And so I recognize that awards differ from state to state. But how do you, as a judge, approach these various cases when perhaps a woman has not been working, her husband or she wants the divorce, but the woman clearly has no income yet? How do you deal with that?
May I just very quickly say that whatever I say here, I'm speaking only for myself.
Absolutely.
Because clearly, if you had 5 judges sitting in this room, you would get 5 different opinions. So my experience, both as a lawyer and as a judge, and then recently as a mediator, has made me very allergic to alimony. I worry about alimony. When Warren says 10 to 15 years, I picture a cliff. What happens at the end of 10 or 15 years? She just falls off the edge, or he falls off the edge if he's the recipient. So I'm always looking for a more long-term solution. And if you have parties who have means, then you have really all kinds of options available to you as a judge or even as a mediator to suggest that maybe one spouse should take 90% of the assets, put them in a bank, get a financial advisor, and look to see if the assets can generate sufficient income. Because the difficulty with alimony is not just that it's such a variable, and not just that 5 different judges will make 5 different decisions, but it's also an ongoing binding of parties who are generally trying to separate their lives.
So what you're saying is, rather than assessing a particular rate or a particular length for alimony, you're saying look at the assets, look at what one person is capable of having earned during the time of that marriage, and then award the person who has not earned the money but perhaps has stayed behind to raise the children, keep the home, and so on, while the other individual who has earned that money is going to likely go on
Continue.
to earn even more money. So you're saying separate the two, but give one 90% of the asset. Cheryl, how does that sound to you?
Well, first of all, the significant majority of cases are resolved by agreement without ever getting into the court system.
I'm glad to hear that.
And they are solved with creative, thoughtful assessment, and generally by people trying to be fair to each other. Courts tend to be required to do equity, certainly family law courts. Equity is fairness, and what's fair can be significantly different one case to the next, which is why general rules and following very firm guidelines don't work in those few cases that require court involvement. They are normally the extreme cases. They are normally the cases that have the greatest degree of hostility and bitterness. They are often the cases that have unique circumstances that require some additional evaluation. The parties are unable to proceed on their own, and the court then tends to try to come up with a fair and equitable resolution. And sometimes they do a good job of that, sometimes they don't. That's why we have appellate courts. But the reality is that there are benefits to using alimony. Alimony is deductible to the payor. The person receiving alimony pays taxes on that. And when there's significant disparity between the tax rate of the person who's earning the significant income and the person who will receive alimony, creative measures between attorneys, financial planners, and accountants can actually keep more money in the family by using that very appropriate process of paying alimony.
So what are your specific concerns about ending permanent alimony as an option?
Well, my concern is that it's not going to solve the problem. Currently, almost every situation involving alimony is modifiable, so that if the payor becomes ill or retires, has an accident, something significant occurs that hadn't been contemplated, the parties generally on their own come to an agreement to modify. And in those few cases that go to court, the court has the ability to modify based upon what's fair. To have an absolute cutoff date when one party is predicted to be prepared to be able to meet their own needs because the court assumes or the law assumes that after a period of 10 years, let's say, they're going to be just fine. The reality is that in many cases, 10 years is just not appropriate to terminate all alimony. So having the ability to predict the future is not something that most judges are capable of doing, and certainly we lawyers aren't capable of doing that, which is why modification and the ability for people to sit down and try to resolve situations where there have been changes or the court of necessity seems to me to be much better than having an absolute cutoff after a period of time.
Let me turn to you, Anne. Were there any circumstances under which you did award permanent alimony.
Absolutely.
Can you give me an outline?
Sure. The statute really does provide for that. We really have a fairly kind statute because although it sets out this aspiration of a limited alimony, it does provide that even if somebody who has made best efforts to become self-supporting isn't, or even if they're self-supporting, I'm not sure what that means, for instance, in an affluent county, what that means to be self-supporting, but if the disparity in income between the recipient and the payor is what they call shocking, shocks the conscience. And I've had cases like that. Somebody at best could earn $30,000 and the other spouse is earning over $1 million. That's going to be an indefinite alimony case.
What do you think about that, Warren?
I don't. First of all, I really agree with a lot of what Judge Sunt is saying, and that is that that assets, for example, are a better way to go because many times second wives or second husbands, especially second wives, they feel when a check is being paid out to the ex, it seems to have an emotional impact that's very negative on the second wife. And so that's so if there's enough assets to divide, that's probably a good way to go in terms of having the psychological damage or remnants of the first marriage a little bit more free for a parent. I think that there is. I think there is a value to having both the aspiration be limited and also the amount of time being limited under almost every circumstance. And the law can never be. People are much more complex than a law is, and so I think the need for flexibility is really important. But I think that if a person knows I'm going to have 10,000 coming to me this year, 8,000 the next, 6,000 the next, and so on, they can plan accordingly and adjust accordingly.
But on the other hand, what about concerns regarding, say, disabled or older wives or a husband, Cheryl?
Well, that's a significant concern, and that's why having very significant rules that don't provide with the ability for the courts to consider those extraordinary circumstances is really inequitable and unfair.